Good morning. Welcome to the Supreme Court of the United Kingdom. This morning we're hearing the appeal in the state of Libya against General Dynamics United Kingdom Limited. The appeal raises questions about how to enforce an arbitral award against a foreign state within the framework of the State Immunity Act 1978. In particular, whether the State Immunity Act requires service of certain documents on the state concerned through the Foreign, Commonwealth and Development Office, whether an arbitration claim form is within the category of documents required by Section 12(1) of the State Immunity Act to be served on a state through the Foreign Office, and whether in exceptional circumstances the court can make use of certain rules of English civil procedure governing litigation proceedings to dispense with such service. I'm Lord Lloyd Jones. I'm sitting this morning with Lord Briggs, Lady Arden, Lord Burrows.
Good morning.
And Lord Stevens. Libya is represented by Harry Matavu, Queen's Counsel, and Lucas Bastin. The Respondent, General Dynamics United Kingdom Limited, is represented by Daniel Toledano, Queen's Counsel, and James Ruddle. Mr. Matavu.
My lord, my ladies, my lords. As your lordship has said, I have the honour of appearing with my learned friend Mr. Bastin on behalf of the appellant, the State of Libya, and my learned friends Mr. Toledano, Queen's Counsel, and Mr. Ruddle have the burden of appearing on behalf of the Respondent General Dynamics. My lady, my lords, the court has received the written cases of both parties. And in the limited time available to me, I do not propose to repeat what is in our written case, but we stand by it. Nor, my lord, my lady, can we deal with everything in my learned friend's written case. But what I will say as I embark on my written oral submissions is that it is a sea full of canard and red herring, which your lordships and your ladyship do not need to deal with in great detail once you come to write your decision. 7 points by way of example. First, it is suggested by my learned friends that, and they say this in their introduction to their written case, that Libya is one of, quotes, many states which continue to insist that it is entitled to absolute immunity, even though that doctrine has now been replaced by a doctrine of restrictive immunity. They say that at paragraphs 1 to 6 of their written case. Libya is not insisting on absolute immunity, and the court will know that. It is simply insisting on being accorded the procedural privileges to which it is entitled under Section 12 of the State Immunity Act when a claimant seeks to implead it before the English courts. Another red herring, the suggestion that once it is accepted that a state is subject to a domestic court's jurisdiction, the method by which proceedings are commenced and served cannot always depend, they say, on the state's consent or participation. Again, that is not Libya's case. Libya is simply insisting on the procedural privileges which the municipal forum has granted it by way of domestic legislation. A third red herring, the adoption by my learned friends of the rhetorical imprecation in paragraph 7 of their written case. Of what use, they say, is the restrictive theory of immunity if service cannot be obtained? Well, that is a somewhat operatic outburst from Professor Bishop back in 1962, and the court has that reference in the bundles. An outburst in relation to a case where the Canadian court had simply held that proceedings against Canada had not been served on that state by serving papers on its consul general in New York, since he didn't qualify as, quotes, the managing agent, close quotes, of Canada for the purpose of service. And Professor Bishop simply wished that the rules for service were different. Another red herring, the assertion that Libya is seeking to frustrate the enforcement of an arbitral award against it, where exceptional circumstances have made it unduly difficult, as they put it, to serve documents by diplomatic channels. Again, Libya is simply insisting on its statutory privileges under Section 12 of the State Immunity Act. And if it has those privileges, in our submission, it cannot reasonably be criticised for insisting on them. In any event, Libya has made it clear that it stands ready to be served by the Foreign Office. This is not a case like some of those that your lordships and your ladyship may have seen in the authorities, where a foreign state is being recalcitrant about service. My lady.
I wanted to ask, thank you for letting me ask this question at this stage. I wanted to ask whether it was possible to serve on the Libyan embassy here in London, or whether that could only be done by arrangement.
We say that we submit that it is not possible under the State Immunity Act. And your ladyship is right. If under Section 12(6) of the Act, Libya had agreed that that would be a form of service, then that would be permissible. But absent such agreement, it is not.
And do we have the communications with the Foreign and Commonwealth Office?
The communications in their efforts to effect service, my lady?
Yes, it's really the respondent's communications, I suppose.
Yes. I think
Have you
perhaps
seen them?
Where do we find this, Mr. Matavu? It's rather important, I think, that we should know what has happened and what explanation the Foreign Office has given for its inability to serve the document.
Yes. My lord, your lordship and your ladyship see that in the judgment of Lord Justice Males and in the judgment of the Court of Appeal, which endorses or doesn't criticize in any way Lord Justice Males's findings. And the position is in the judgment of Lord Justice Males at, and I hope this reference will appear right, in the core bundle at page 188. What I'm taking the court to is paragraph 84 in the judgment of Lord Justice Males below. And there is not very much there. And what is said is that the evidence established that much of Libya was in a state of civil unrest, that's 4 lines into paragraph 84, and was violent, and there was a real risk of full-scale civil war. And then Lord Justice Males finds that the British embassy had closed, with diplomats moving to neighbouring Tunisia, although visits to Libya were sometimes possible and some diplomatic staff remained in the country. There was at least uncertainty as to the time which would be required to effect service through the Foreign and Commonwealth Office, assuming this was possible at all. There were some periods when it would have been dangerous to attempt to deliver documents to the Ministry of Foreign Affairs as a result, not only of the situation in Tripoli generally, but also the presence of armed militia around the ministry itself. My lords, my lady, in this case, no attempt was made to effect service through the Foreign and Commonwealth Office. No attempt was made. And so that is another situation in which this case is very different from, for example, Haiza, an Iranian case, where the Foreign Office did its best to effect service. That is one of the striking facts about this case.
Thank you.
Thank you.
My lord, my lady, The next red herring is this, that it is submitted by my learned friends that the observation...
Forgive me 1 moment, Mr. Matterbury. I'm afraid we've lost Lord Stevens.
Oh.
Tell me.
I think we've got Lord Stevens back now.
Yes.
Yes, sorry, I had just totally lost sound and I had to leave the meeting in order to come back into it again. I'm sorry about that.
Super. Thank you.
Thank you. Well, just to inform my Lord Stevens that I was only embarking on my next point, so he's missed nothing since falling off his chair at the news that no attempt was made to serve the Foreign Office. Yes, my Lord.
Yeah. Well, what I would like to know is why the state of Libya, apart from reciting that it wants to stand on its privileges, does not agree to an alternative method of service. So I can have a note of it.
Yes, because, my Lord, if Libya agrees if Libya were to accept that Section 12 could be dispensed with, that it would not be satisfactory. Your Lordship asks me, yes, your Lordship asks whether, pursuant to Section 12.6, Libya could agree to accept service in another way. My Lord,
and that is in the context, of course, that it knows about these proceedings. It actually has a copy of the proceedings and has access to legal advice about it.
It has, yes. My Lord, Libya has not been asked to agree to that. And as matters currently stand, my Lord, even if Libya did agree to that at this stage, the position is that there is a judgment of the Court of Appeal binding in relation to all claims against foreign states, which Libya does not wish to remain as the law in this country.
So, apart from the legal principle that would be established or would be left outstanding, Libya's got no objection to agreeing. Is that right?
My Lord, I have no instructions on that, but I can take them.
Yep. Thank you. Thank you very much indeed.
Thank you, my Lord. So the next red herring is the observation that Libya is not appealing the determination by Lord Justice Males at first instance that the circumstances prevailing at the time when the matter was before him were exceptional as far as service through diplomatic channels was concerned. But there is no need for Libya to appeal that. If Libya is correct on its interpretation of Section 12, that consideration is simply irrelevant. There's no room for it on Libya's interpretation of Section 12. And then another red herring, which occupies many pages of my learned friend's written case, is that there is no procedural rule of customary international law which requires service of a document through diplomatic channels in every case where the court is impleaded, where a foreign state is impleaded in domestic courts. Now, my lady, my lords, we can argue about that, having regard in our submission to the codification of such a rule in Article 22 of the UN Convention on Jurisdictional Immunities, and having regard to the status accorded to that convention by this court in Jones and Saudi Arabia, and in Belhaj, I think the House of Lords in Jones and Saudi Arabia, this court in Belhaj, which described that convention as, quotes, powerfully demonstrating international thinking and as an authoritative statement of customary international law. We can debate that having regard to the European Court of Human Rights judgment in the case of Wallihauser, where the service provision in Article 22 of the UN Convention, which is similar to the service provision before this court today, was expressly held by that court to reflect customary international law binding on Austria. And we make reference to that for your lordships and your ladyships note at paragraph 3.74 of our written case, 3.74. But in any event, what is apparent is that all other jurisdictions which do have statutory provisions requiring service of process through diplomatic channels, whether it is a rule of customary international law or not, make it clear that such a mode of service is mandatory. And we say that in paragraph 3.7 of our written case. And finally, we treat as a red herring, and we submit it is a red herring, the suggestion that the construction for which Libya contends would infringe Article 6 of the ECHR. Now, the respondent has not sought a declaration of incompatibility with the European Convention of Human Rights. Indeed, in its written case, it has expressly disavowed such a declaration. Instead, it has now abandoned the suggestion in its notice of objection that there's an infringement of Article 6, and it now simply invites the court to construe or interpret Section 12 in a way which is compatible with Article 6. Well, we submit that our construction is indeed compatible with Article 6. Now, the court has been regaled with a blizzard of authorities and legal texts, and we certainly won't get through all of those in the time available. However, in our submission, this appeal can be decided by reference to certain fundamental principles of statutory interpretation and certain fundamental principles of international law. And so my approach, with your lordships and your ladyships' leave, will be to invite the court first to consider the issue of general importance that arises and the implications of the judgment of the Court of Appeal for the impleading of foreign states before the English court. Then, since this case and this appeal concerns the interpretation of statutory provisions, to remind the court of the correct approach to statutory interpretation, grandmothers and eggs perhaps, but unfortunately in our submission, these basic principles were not adopted by the Court of Appeal in this case, or indeed by lower courts in other cases to which your lordships and your ladyship have been referred, when considering the important statutory provision concerning service of process on a foreign state. And then third, we have been criticized in my learned friend's written case on the grounds that our written case does not, quote, engage at all with the language of the section. That's paragraph 15 of my learned friend's written case. We don't, of course, accept that, because if your lordships and your ladyship look at paragraphs 5.4 to 5.9 of our written case, referring in particular to the judgment of the High Court of Singapore in Van Gil and Lesotho, which considered a materially identical provision, you will see what we say there. In any event, we shall engage fully at this hearing, not just with the language, but also with the full interpretation of the statute, which of course goes beyond language and includes context and legislative purpose, something which in our respectful submission is rather skated over in the respondent's interpretation. And then we shall address briefly the respondent's remodeled point on the ECHR, which is now a section 3 point about interpretation, not an Article 6 infringement point. We shall do so briefly because we do not want that tail to be allowed to wag the respondent's dog. So there's a lot to get through, and I start with the issue of general importance. My lady, my lords, the issue in this appeal concerns the impleading of foreign sovereign states before the English courts, as we know. It engages the question of the immunities and privileges of foreign states under English law, foreign sovereign states under English law, having regard to the fact that sovereign states have always been afforded a special status before municipal courts as a matter of international law. Even in an age where the doctrine of state immunity is no longer absolute in this and in many other jurisdictions. the status of sovereign foreign states before municipal courts is special. And the issues of impleda that are raised are issues where in this jurisdiction, the law is regrettably in a state of some confusion and, in our submission, disarray. It was not ever thus. A quarter of a century ago, it was established on the highest authority, Kuwait Airways and Iraqi Airways number 1, that the requirements of Section 12 of the State Immunity Act are mandatory. That was a case, my lady, my lords, where Iraq, under the regime of Saddam Hussein, had invaded Kuwait and seized a number of aircraft belonging to Kuwait Airways Corporation. And Kuwait Airways sought to sue the state of Iraq in the English courts for wrongful interference with its assets, and it sought to serve a writ in accordance with Section 12(1) of the State Immunity Act. In the absence of a UK diplomatic presence in Iraq, the Foreign Office sent a copy of the writ to the Iraqi chargé d'affaires at the Iraqi embassy in London for onward transmission to the Ministry of Foreign Affairs in Baghdad. The Iraqi diplomat in London failed or refused to do so. Nevertheless, the House of Lords endorsed the decision and reasoning of Mr. Justice Evans below, as he then was, to the effect that the writ had to be served at the ministry in Baghdad. And the Appellate Committee did so, notwithstanding problems arising in the aftermath of the Gulf War, in particular, the absence of a UK diplomatic presence in Baghdad, notwithstanding the apparent inability of the Foreign Office easily to effect service by transmission of the writ to the Ministry of Foreign Affairs in Baghdad. And the House of Lords so held without raising any question about complications or the exigencies of prevailing conditions in Baghdad or the absence of a diplomatic presence there. It was simply a question of applying what the statutory provision said. And may I invite your ladyship and your lordships to look at that authority. It's in what we call the Principal Authorities Bundle, tab 16 at page 546. And having introduced the case, I was going to invite the court to go to page 554 in the speech of Lord Gough of Chieveley. And to look at letter F in the report, where it said that on the 14th of January 1991, a letter from the Foreign and Commonwealth Office was sent to the Iraqi embassy, that's the Iraqi embassy in London, enclosing the writ and stating that as Her Majesty's government had no representation in Iraq at the time, the Foreign and Commonwealth Office would be grateful if the documents could be forwarded to the Ministry of Foreign Affairs in Baghdad. The documents were received at the embassy on the 15th of January by Mr. Ibrahim, an accredited diplomat. He'd previously received a copy of the proceedings, which had been served at IAC's London office on the 11th of January and had faxed a copy to the Iraqi embassy in Jordan for onward transmission to the Ministry of Foreign Affairs in Baghdad, but he'd received no reply. He did not attempt to forward to Baghdad the documents received from the Foreign and Commonwealth Office on the 15th of January. So pausing there, the roadblock to a suit by Kuwait Airways in the English courts was created by an Iraqi government diplomat. But that was too bad, because as the court reads on at H, 2 lines into that paragraph, His Lordship Lord Gough said that the argument advanced by Kuwait Airways before Mr. Justice Evans was rejected by him as being inconsistent with the express terms of Section 12(1). He said, "In my judgment, the requirement of service at, not merely on, the foreign ministry of the defendant state is no more and no less than the plain words of Section 12(1) demands. Service is to be effected by transmission to the ministry and takes effect when the document is received at the ministry. In no sense is a diplomatic mission in a foreign state the same as the Ministry of Foreign Affairs of the sending state." And then this, Lord Gough says, Mr. Justice Evans cited a passage from Lewis on state and diplomatic immunity, which reads as follows. "It would have been possible to provide for service within the jurisdiction on the embassy, on the analogy of a foreign company carrying on business within the jurisdiction. However, it was no doubt considered more diplomatic that the foreign sovereign should not, by reason merely of his mission's presence here for the purpose of diplomatic intercourse between the two countries, be deemed to have a legal presence within the jurisdiction." And so, my lady, my lords, Lord Gough, with whom all the other law lords agreed on this issue, focused on that passage in Lewis, which draws attention to the likelihood that the statutory requirement had regard to sensitivities of international relations, and the fact that legislators could easily have made provision for a more relaxed requirements as to service if they had so wished. And so that, in our submission, was a very clear and very straightforward decision which all could understand and follow, whether they be claimants or whether they be prospective defendant foreign sovereigns. However, since the millennium, the English courts have taken a rather different course. They have been faced with cases formed in the crucible of highly charged international politics following 9/11, where foreign sovereign states, notoriously dubbed part of the axis of evil, have objected to the pursuit against them of collective claims for damages by victims of alleged state-sponsored terrorism, or cases arising out of internal political or civil strife within sovereign states, or cases heard against a new background following the growth of international arbitration and the enthusiasm, particularly of the commercial court, to be seen as supporting arbitration. And faced in all these circumstances with the question whether in such a situation a foreign state had been properly impleaded by the English courts or before the English courts, often for the purpose of enforcing a judgment or, as in this case, an arbitral award against it, the English courts have sought to cut the Gordian knot of complex international politics so as to allow claimants to pursue claims against foreign states by the following approach. They determine first that these classically political circumstances are exceptional, notwithstanding that civil strife within states, international discord between states, are as old as time. They then take into their own hands as courts the situation arising out of such classically political circumstances, which they now classify as exceptional, to allow them to invoke a judicial discretion under their procedural rules relating to service of process against a non-state defendant. And in that way, they persuade themselves that they can dispense with the special statutory privileges granted by the legislature to foreign state defendants. Statutory privileges granted to states against the application to them of the procedural rules which the courts now invoke. And the courts are ready to do so, notwithstanding the risk of damage to the internal relations, the international relations of the government by such judicial activity. And they justify that approach by interpreting Section 12 of the 1978 Act without proper regard, in our respectful submission, to the fundamental principles of statutory interpretation, in order to suit the modern procedural code of the court, a new procedural code with court management provisions, which there is no suggestion that the legislators had contemplated in the mid-1970s at the time when that legislation was made, and which there is no suggestion that the legislators of this millennium wish to provide for by amending the 1978 Act, even though it would be very easy for them to do so. My lady and my lords, this zeal of the courts to allow claimants to pursue claims against foreign states without ever having to serve process on the state is a dangerous enthusiasm. It's dangerous for the conduct of international relations by Her Majesty's government, as some of the cases have shown, and it's confusing for the law in this increasingly important area. And so, in one case 2 years ago, and that's the case of certain underwriters against Syria, and I don't propose to turn it up at this stage, the commercial court held that service of process on a foreign state is affected under Section 12 of the Act when documents required for instituting proceedings are received by the Ministry of Foreign Affairs of the state in question, notwithstanding that physical delivery of such documents may be resisted by staff at that ministry. However, in a subsequent case, in the Queen's Bench Division last year, that's Heiser against Iran, also in our authorities, the Queen's Bench Division held that the decision of the Commercial Court was wrong, and that if a foreign state refused to accept a document delivered to its Ministry of Foreign Affairs, the document had not been received within the meaning of Section 12 of the Act, and so the state had not been properly served with a judgment. Now, we say that that decision was clearly wrong with respect and should be disapproved. If a letter bomb is passed through my letterbox, I have received it, even if I have a code name 007 and I'm able immediately to open the door and kick the letter bomb back out into the rucksack of the person who sent it, with satisfying cinematic results to follow. I haven't wanted to receive the letter bomb, but in normal English language, I have received it. And yet in the same case of Heiser in Iran, the Foreign Office, which is charged by the legislator under the Act with the responsibility of effecting service on foreign sovereign states, got itself into a complete muddle as to whether or not it could certify that service had been effected in accordance with the requirements of Section 12. And on top of this, the deputy judge, as he then was, Mr. Andrew Henshaw QC, in the first case of certain underwriters, had opined obiter that if the court, in the exercise of its discretion under the CPR in the particular circumstances of that case, had permitted a claimant to dispense with service of a claim form or other document instituting proceedings, that was not a document required to be served within the meaning of Section 12 of the Act. And the Court of Appeal has held likewise in the present case in relation to claims to enforce arbitral awards. And so, my lady, my lords, this confusion in the law has been allowed to develop in a world where claims against states are becoming ever more frequent, where those claims are potentially massive, often causing serious threats to a state's budget, foreign currency reserves, credit rating, and the ability to raise debts on the money markets. And the English courts have seen examples of that in recent cases, P&ID in Nigeria being one, Law Debenture Trust in Ukraine being another. And this is developing in a world where states keep their assets in jurisdictions outside their own territories, which therefore render them prospective targets for enforcement proceedings. Something has gone wrong. And we submit that the courts below have lost their moorings in basic principles of interpretation and basic principles of international law. None of the cases referred to have properly considered the provisions of Section 12 in their context within the State Immunity Act, and none of them have properly considered the provisions of Section 12 against the background of the underlying policy and purpose of those provisions and of the Act. And this appeal is an opportunity for the court to put that right and to bring coherence back into the law in this area. Now, my lady, my lord, specifically, this is an appeal from the judgment of the Court of Appeal, the effect of which is that the procedural privilege granted to foreign states by Section 12 can very easily now be dispensed with in any case where a claimant seeks to claim against a foreign state, whether it be a claim to enforce an arbitral award or any other claim. And it can be easily dispensed with by the very simple expedient of a court exercising a discretion to allow a claimant to dispense with formal service of suit on a state and simply to substitute notification of proceedings on a state. And that is a discretion which can and will be and has in this case been exercised by a judge sitting in the Strand on an application by a claimant without notice to the foreign state, an application which can be determined either in court ex parte or even on the papers. A determination which can be made by the exercise of a discretion, which is usually unappealable, by a judge who will not have a full appreciation of the issues of diplomacy and the political complexities which may attend relations with the foreign state, considerations of which the House of Lords was fully aware in the Kuwait Airways case, a judge who will not have a full appreciation of such issues, unlike the Foreign Office, the arm of the executive recognized by the legislation as the appropriate agent to decide how, when and where to transmit documents for service on a foreign state.
Mr. Matavu, are you suggesting that the Foreign Office has any discretion as to whether to act as a conduit for service in accordance with Section 12?
My Lord, I would submit that the Foreign Office has a discretion as to how to transmit documents and even when to transmit documents, because there is nothing in Section 12.1 which circumscribes that. Indeed, there is nothing in Section 12.1 which provides a restrictive interpretation of the word transmit.
So could it simply decline transmit?
No, that we would submit that that is certainly not the part of the legislative intent. It would, the expectation would be, the clear legislative expectation is that the Foreign Office would transmit. But the legislation leaves it to the Foreign Office to determine how and when, and indeed, as I will show your lordships and your ladyship in due course, the legislation expressly provides by Section 21 that a certificate from the Foreign Office certifying that it has effected service is not just evidence of that fact, as one sees in CPR 6.44, the rule of court which incorporates Section 12, but that it is conclusive evidence. So the legislature expects the Foreign Office to do its job and trusts the Foreign Office to do that job and to give an accurate certificate that it has done so.
So forgive me, could the Foreign Office then delay indefinitely the service of the proceedings?
I'm sorry, my lord. We would submit that it's not a matter of delaying indefinitely. It's a matter of choosing what is right, having regard to the political sensitivities that may also prevail in the circumstances. Now,
is there any indication in any authority which suggests that the Foreign Office has such a discretion?
Well, the authorities show that the political considerations are an acute issue to bear in mind when, and I shall take your lordships and your ladyship to this, when looking at the question of service.
Well, that may well be the reason for the provision. But is there anything in the authorities to suggest that the Foreign Office has the discretion that you suggest it has?
Well, we would submit that that is the authorities that make the point I've just put to your lordship do contain that implication. And so, yes, well, an example, my lord, we shall come back to that. An example, my lord, is this. One can look at it from two perspectives. First of all, there is a claimant who wishes to enforce its claim or pursue its claim against a foreign state immediately, and it sends the documents to the Foreign Process Service in the Royal Courts of Justice for onward transmission to the Foreign Office. It cannot have an expectation that its timetable will be met by the Foreign Office according to the wishes of the claimant. Of course, the Foreign Office will do its best to comply with its duty to effect service. That is the legislative expectation. But if the legislature expected the Foreign Office to do so within a particular period, it would have said so in Section 12. It doesn't. If the legislature had expected the Foreign Office to do so by a particular mode, it would have said so in Section 12 of the Act. It doesn't. It simply says transmit. But my lord,
we mustn't take up too much time on this because you've got a lot of ground to cover, Mr. Matterville.
Yes.
But my recollection is that there's a passage in the White Book in which the Foreign Office has set out an indication as to the time likely to be taken in effecting service. But I don't want to take you out of your course at the moment because you've got a lot of ground to cover.
Yes.
And limited time.
Thank you, my lord. Indication is indeed the word. My lord, I was going to take your lordships and your ladyship to a stark example of the dangers of an exercise of judicial discretion in a case such as the one I have described, and that is the present case before your lordships and your ladyship. When the ruling of Mr. Justice Tier Mr. Justice Tier made a ruling when he made his enforcement order in which he gave permission to the claimant to dispense with service on Libya. And may I invite the court to look at Mr. Justice Tier's original ruling in the core bundle at page 168. And so this was on a without notice application, and it's a short ruling, as is so often the case on such applications. And in paragraph 1, Mr. Justice Tier explains 5 lines into the paragraph that the court has jurisdiction to dispense with service and that he had concluded that it was appropriate to do so in the circumstances of the case. Paragraph 2, on the basis of the evidence to which I have been referred, it's clear that the state of Libya is aware of the award because it was represented by the law firm based in France in that arbitration. Further, it's clear from matters to which I've been referred that the state of Libya is aware that the substantial arbitration award remains to be paid. And then the difficulty of service in this case arises from the circumstances that if the claimant were to seek to serve the arbitration claim in the manner provided by the Act, there would be considerable difficulties arising out of the circumstance that there are at least two entities claiming to be the state of Libya at the present time. Pausing there, as Lord Justice Mayles made clear on the inter partes application, only the government of national accord had in fact been recognised by Her Majesty's government and the UN as the government of Libya. And then Mr. Justice Tier continues, the court has to balance the interests of the claimant to enforce the substantial award against the interests of the defendant to be made aware by a formal process of service of the steps being taken in this court. However, it seems to me, weighing those interests in the balance, that it's fair and just to grant the order sought, because otherwise the claimant would be unable to take the steps it wishes to enforce the award and would have to await until such time as conditions in Libya become more normal. I don't consider that making this order will in reality prejudice the interests of the state of Libya, because as I've said, the state of Libya must be aware of this award and of the claimant's interest in enforcing it. Further, the claimant will take certain steps to bring this order to the attention of those who there is reason to believe can make the state of Libya aware of these proceedings. My Lord, at that stage, there was no analysis, my lady, at that stage, there was no analysis of Section 12 or of the procedural privileges of a foreign state, and strikingly, there was no determination that there were any exceptional circumstances to justify this somewhat imperious exercise of discretion. Now, Lord Justice Mayles, in his judgment later on, observed that Mr. Justice Tier had not relied on the struggle for power between two political factions in Libya as justifying dispensation from service. The justification was simply that Libya had participated in the arbitration and so was aware of the award. And therefore it must be aware that an attempt to enforce it may come. But pausing there, why should a foreign state which has participated in adjudicative proceedings by way of an arbitration have any knowledge as to where enforcement may be attempted, in what jurisdiction, over what assets? Participation in and submission to adjudicative proceedings is very different from submission to enforcement proceedings. And we submit that state immunity or any other jurisdictional objections or substantive defenses can be asserted in enforcement proceedings, notwithstanding participation in prior adjudicative proceedings. Now, Lord Justice Mayles did not support the approach of Mr. Justice Tier when he made his enforcement order. He focused on very different considerations, and as your lordships and your ladyship will recall, he did so obiter. And one can see his judgment at page 171, in which he gave permission to the claimant to dispense at 168, where Mr. Justice Tier gave permission to the claimants to dispense with service. At page 188 in Lord Justice Mayles' judgment, perhaps the court could turn that up, please. Lord Justice Mayles considered the issue of dispensing with service. And I have shown the court paragraph 84 on page 188 as to what Lord Justice Mayles says was the situation in Tripoli. And at paragraph 185, he says, if such conditions, and similarly conditions in Syria and Iran, the other states where orders have been made dispensing with service, do not amount to exceptional circumstances, it is difficult to know what would. Well, exceptional in whose eyes? those of a judge in the Strand. But war and civil war are nothing new, and the legislators of the State Immunity Act would have known that. And the situation described by Lord Justice Mayles in paragraph 84, while exceptional to him and to many of us, would be rather less exceptional to the Middle East or Africa desk of the Foreign Office. They would not be strangers to situations of civil unrest in states with which the government has relations, and yet they conduct diplomacy with them. Nor are they strangers to conducting relations and communications even with states with whom the government has cut off diplomatic relations. They find a way to do so, and the State Immunity Act, to go back to the question that my Lord Jones was putting to me, gives them that latitude, the Foreign Office, that latitude to determine how, where, and by reference to which foreign state with which there may or may not be difficult relations, service is to be effected. And so what this exercise of judicial discretion comes to is that a claimant who seeks to sue a state which the law recognizes as different in nature and status from an ordinary corporate or natural person should not have to wait until the Foreign Office has conducted efforts to effect service, notwithstanding that the Foreign Office is experienced in such matters. And there's no explanation as to why a claimant should be given primacy in such circumstances. And we submit that Lord Justice Mayles was absolutely right in his primary holding that there is no discretion on a proper interpretation of Section 12. Similarly, his conclusion in the very last paragraph of his judgment on page 189, that unsatisfactory as that may be for a claimant, and possibly for a court which wishes to get on with its list, if you choose to sue a foreign state, you take your defendant as you find it. And whether or not he was right to attribute to King David the psalm from which he quotes, "Put not your trust in princes," I don't rely on, I don't make the proposition in reliance on that, the suggestion that a state may be cynical. I rely on the fact that the state may simply be a state which has to deal with which the UK government has to deal.
Right, Mr. Matthew, some questions for you. First of all, Lord Stevens and Lady Arden.
Yes.
Certainly.
I wanted just to concentrate for a moment or two on the situation where there are no diplomatic relationships between this state and a foreign state.
Yes.
Section 12 requires the documents to be transmitted through the Foreign, Commonwealth and Development Office. Article 22 of the Convention requires it to be transmitted through diplomatic channels. So, which is correct?
We rely on
the same.
We say they're the same, and certainly for the purpose of this case, my lord, we say they're the same.
And so, therefore, if there aren't any diplomatic channels between this state and a foreign state, what do you do?
Well, what happens is what happened in the case of Iran when diplomatic channels, diplomatic relations were cut off. Nevertheless, there was still diplomatic communication, and that was affected by the Foreign Office relying on an allied state to be the vehicle through which communication was conducted. I think there's a case, I can't remember whether it's Havlish or Heiser, where the allied state in question was Sweden. And so what happened was that the UK communicated with Iran through Sweden.
And what discretion then, for instance, if you have a the Foreign and Commonwealth Office not performing its function of transmitting a document, you can then bring judicial review proceedings against the Foreign and Commonwealth Office on usual Wensbury grounds.
Yes.
How do you achieve that if Sweden doesn't do it?
Well, it may be that in those circumstances, one has to wait until conditions are satisfactory enough to, or amenable to, allow that to take place. Now, in the Union Fenosa case, which the court will see in the additional authorities bundle at page 2117, the claimant in that case, that was a case where Egypt was the prospective defendant, and that was not a situation such as my Lord Stevens has described, where diplomatic relations had been cut off. But even in that case, the claimant accepted that it might take up to 9 months to effect service on Egypt.
Forgive me, Mr. Mantevu, we can't find the authority at the moment.
I wasn't going to take your lordship to it, but it is...
Right. Just give us the reference again.
The reference is Additional Authorities Bundle. I've got it at tab 50, page 2117. I'll just check that, my lord.
I don't think that's right.
No.
It's not in the Additional Authorities Bundle.
In my...
And page 2117 of the main bundle is Primero Congreso.
No. May we try to find that?
Yes, please.
It's a page 2118.
I'm very much obliged. Thank you. 2118. Union Fenosa against the Arab Republic of Egypt. I'm grateful to my lord.
And what does that say?
I refer to it on the basis that that was a case where it was accepted that it might take up to 9 months to effect service through the Foreign and Commonwealth Office. And I will find the specific reference in the break, if your lordship will.
Yes, of course.
Yes,
thank you.
Paragraph 24. Paragraph 24.
Thank you.
Thank you, my lord. Now, my lord, the Court of Appeal, I'm sorry, Lady Arnold.
We still have Lady Arnold's question.
Yes, I do apologize.
I wanted to go back to the submission that you were making and to ask you whether, in fact, it's reinforced by the basis of the distinction between adjudicative and enforcement jurisdiction. And as I understand it, but you will correct me if I've got this wrong, the basis of the distinction is entirely practical, because when a court is proceeding to judgment, it produces no immediate effect on the state concerned. But when it comes to enforcing a judgment, that involves, in the last resort, the use of force against the foreign state's assets. And to do that, the Forum Court, in this case the UK, requires the assistance of the executive arm of government. And that is liable to give rise to friction. And such seizure is likely to cause in relation, and it's likely to cause a rupture in relations between the two countries, and that is the rationale, historical reason, for the distinction between the adjudicative and the enforcement jurisdiction. I am quoting, obviously.
Yes, my lady, I would bow to the author of that quote and, of course, your ladyship. But without myself having articulated that principle, I would certainly endorse it and adopt it in my submission. And that is, regardless of the historical basis for it, as your ladyship suggests, it is certainly the current basis for restraint and caution when it comes to enforcement proceedings, which we have at the heart of our submission.
Thank you. The text, which is Lady Fox, doesn't say historical. Yes. I added that bit in, but otherwise it says what I had summarised.
Yes.
But that brings us back to my Lord Jones's point. That is, does the United Kingdom state, the Foreign and Commonwealth Office, have any discretion? Because if they don't, And if the executive arm doesn't, then the order has to be enforced and the proceedings have to be served.
Well, my lord, we would say that it's certainly, the Foreign Office certainly has a discretion, and it's a submission I have made, a discretion as to how and when.
Well, it could delay for a bit before for an election to take place or whatever. But if there is ultimately absolutely no long-term discretion, then there may be reticence, there may be courtesy, but at present I can't see how the government would say we're just not going to serve this, or how the government would say we're just not going to enforce this order.
My lord, I accept that there would be a real basis for judicial review if that were the position of the government.
Yeah.
But the reality is there has never been a case where the government has acted in that way, and the State Immunity Act has been in force since 1978. My lords, my lady, the judgment of the Court of Appeal that a judge is entitled to exercise a discretion is that that discretion must be somehow read into Section 12, even though it would have been the easiest thing in the world for the legislators who drafted the section to state expressly that the court could dispense with the procedural privilege granted to foreign states in the exercise of that discretion, whether or not the circumstances were exceptional. And so we then come, my lords, my lady, to the interpretation of Section 12 itself. In our additional authorities, we have referred to the well-known case on statutory interpretation, Quinta Valle and the Secretary of State for Health. In the time available, although I had wanted to take the court to it, I can only refer to Lord Bingham's speech at paragraph 6 for your lordships and your ladyships note and following, where he cites the important dictum of Lord Wilberforce in his dissenting judgment in the Royal College of Nursing case, the dictum which has now, by Quinta Valle, been accepted into the mainstream as stating the law on statutory interpretation in our submission. So Lord Bingham at paragraph 6 to 15, Lord Steyne at paragraph 21, citing Judge Learned Hand in particular. And what one extracts from that authority is that whilst one can start a process of interpretation by looking at the words themselves, one has to consider those words by reference to the context of the relevant provision within the statute, and also by reference, of course, to the policy to which the statute and the provision are directed. It's not simply a question of transposing the dictionary definition of each word, turning the dictionary into a fortress, as Judge Learned Hand said in the passage quoted by Lord Steyne. And the authority of Quinta Valle also makes it clear that the purpose of the statute against which the provision is to be read must be readily discernible from the statute. In particular, unless a legislative purpose is clear in the scheme of a statute or statutory provision, the court should not infer a purpose which is not set out in any provision of the Act itself. And so, bearing those principles in mind, we can look at Section 12 itself, which the court will find in tab 1 of the authorities bundle, page 8, my lords, my lady. If I can take the court straight to Section 12 on page 13 of the bundle, 12.1 I hope is available to the court, and we submit that it should be read as follows. A, any writ, or B, any other document required to be served for instituting proceedings against a state shall be served by being transmitted through the Foreign Office. My lords, my lady, syntactically, that is an available interpretation. And it makes perfect sense. As to A, any writ, everyone knows that a writ is a document that institutes proceedings. This doesn't need to be explained in the statute. And so there's no need to assume that the legislators intended to explain a writ with the phrase required to be served for instituting proceedings against a state. That describes the documents that follow. And as to B, any other document required to be served, etc., there were indeed documents at the time when this act was promulgated, documents other than writs by which proceedings could be instituted. And the obvious example is an originating summons, now a Part 8 claim. And the wording of Section 12.1 simply reflects Article 16 of the 1972 European Convention on State Immunity, which is referred to in the long title of the State Immunity Act, albeit in relation to Part 2 of the Act. It is clear that the European Convention was on the desk as the draftsmen were drafting this in our submission. And may I invite your ladyship and your lordships to look at that convention. It's in the alternative additional authorities bundle at page 1411.
I don't think so, Mr. Madhu.
Oh,
I think that's the Convention on Human Rights.
I'm looking for the European Convention on State Immunity, my lord.
Yes.
Tab 21. I have the Convention on Human Rights of 1408, so it is the next document.
Yes, 1412.
I think we're a page out all the time, my lord. I do apologize. 1412. And your lordship sees and your ladyship see in the preamble that member states of the Council of Europe have agreed as follows. And if your lordships and your ladyship go to the next page, 1413, Article 16 is there set out. And Article 16.2 provides that the competent authorities of the state of the forum shall transmit the original or a copy of the document by which proceedings are instituted through the diplomatic channel to the Ministry of Foreign Affairs of the defendant state. Shall transmit is mandatory. And there's no emphasis there on whether or not service of the document is required. We submit that that phrase is simply descriptive. And that is the sense in which Section 12 is to be read. That all the appositional phrase required to be served is doing is identifying a class of documents required to be served to be served for instituting proceedings. Which then brings us to instituting proceedings. My learned friends contend that this must refer only to the document which generates the proceedings. We disagree. Institute, in its natural and ordinary meaning, means to establish, to put into effect, instituting a program, instituting an educational regime. And here, establishing proceedings against a foreign state or putting them into effect involves bringing them to the attention of the foreign state so that the latter knows that there is a claim against it and its appearance is required in the forum courts. So, in a process of instituting proceedings against a foreign state to enforce an arbitration award against it, the document in question is that which is ordinarily to be served to command the appearance of the foreign state before the court. And if it is not the claim form, then, in this case, it is the enforcement order which granted permission to enforce, which is ordinarily the document which has to be served on the prospective defendant to an enforcement action. Lord Justice Mayles was absolutely right in his analysis. And again, we submit that that reflects the simple thrust of Article 16 of the European Convention on State Immunity. One is simply looking for the document by which proceedings are instituted. No cheese pairing is required in that interpretation. And that reflects and is supported by European case law, and we refer in our written case to the case of Firma Hengst, which is worth just looking at briefly. I have that in our primary authorities bundle. My reference is 733, but it may for your lordships be 734 and your ladyship.
Mr. Matavu,
Yes, Lord Burrows, yes.
May I ask a question? Taking you back to 12 subsection 1.
Yes.
You've given us your preferred interpretation for instituting proceedings. My question is, why is it that those words are included at all? Why aren't we in line with the policy that you've put forward, requiring all documents which are required to be served against a state to be served through the Foreign and Commonwealth Office? What are the words instituting proceedings, do you think, particularly adding in the context in which you've told us you may require, because of sensitivities, etc., the service through the Foreign and Commonwealth Office?
We would submit, my lord, because as one sees from the heading to section 12, this is concerned with service of process and judgments in default. And second, the issues of sensitivity and political complexity to which I've referred arise at the moment of prospective impleader of a state. Once a state is before a municipal court, then it is engaged in the proceedings, and service of documents can proceed in what I might call the normal way, pursuant to the rules of court in which the foreign state is now engaging.
Thank you.
Right. Mr. Matavu,
I'm sorry, my lord.
Before we leave that point, why doesn't section 12.1 then say any writ or other document instituting proceedings against a state shall be served? Why add in the additional words required?
Well, any other document required to be served for instituting proceedings, we say required to be served is, it could have said instituting proceedings, but insofar as you have a document, it's the submission I've already made, my lord. It is simply a descriptor of the sort of the class of documents that are in consideration.
But do you need those words to be a descriptor? Any writ or other document instituting proceeding?
One could say, one could have drafted it in that way. One could also have drafted it in the way that it has been drafted, and there is no surplusage or offensive surplusage in using the words required to be served.
And are those words a departure from the convention at page 1412? That is requirements, the requirement.
I'm sorry, my lord.
The convention doesn't have that. Sorry, 1413.
1413.
But that's an addition imposed by the legislature in this country.
Yes.
But you say
Well,
it adds nothing.
My lord, that adds nothing material.
Okay. Yes. And would in order to be compliant with Article 16, would a counterclaim have to be transmitted through? Why not? Because Article 16, the competent authorities of the state of the forum transmit the original or a copy of the document by which proceedings are instituted. And the counterclaim institutes proceedings against the state.
Well, provision is made in relation to counterclaims in the 78 Act by section 12.7.
That's a departure again from the convention.
Well, your lordship suggests it's a departure from the convention. We would submit it's not a departure.
Yeah.
It's an implementation of the convention in terms which are familiar in the procedure of the English courts.
Thank you very much.
My lord, I note the time.
Yes, that might be a convenient moment. Just point out for Lord Briggs' benefit, there was a supplementary bundle served yesterday, but it only has 2 authorities in it. And we've already been referred to one of those.
But I was assuming, looking at the page numbering, there was another bundle of authorities between the main one and that one that we were served yesterday, which at the moment I can't trace. And
No,
which
I don't think any of us have that.
Well, isn't that the one that contains the convention?
No, that's the main bundle.
Ah. Yeah, well, that may be the solution. Thank you.
Yeah, well, we'll take 5 minutes, Mr. Matavu.
Thank you,
you have until 12:30.
Yes, I'm going to review.
Yes, right. Thank you. We'll take a short break now.
Thank you.
Mr. Matavu.
My lord, I was just about to take the court to the Firma Hengst case. That is at, I hope, 734 of the Additional Authorities bundle. That was a case in the European Court. Sorry, Primary Authorities bundle. I do apologize.
Yes.
Hengst-Port against Campese. 734, I hope. That was a case in relation to Article 27.2 of the Brussels Convention. So it concerned a different convention. I'm taking the court to it because of what it says about the phrase instituting proceedings, bearing in mind everything that we know about the caution that must be exercised when looking at a different convention. Nevertheless, it is instructive if your ladyship and your lordships look at the judgment of the court the Advocate General's opinion is also illuminating, but the judgment of the court at page 748, paragraph 19, it may be 749, I'm sorry, but it's in any event paragraph 19, where the court says that the term document which instituted the proceedings or equivalent document within the meaning of Article 27 of that convention means the document or documents which must be duly and timeously served on the defendant in order to enable him to assert his rights. And so we would submit that in answer to my Lord Stephen's point, that the reference that supports our reading of section 12.1, that documents required to be served, is simply a descriptor. And that the European language, if I can put it that way, in Article 16 of the State Immunities Convention is not to be read any differently. There's no reason to read document for instituting or by which proceedings are instituted any differently in that convention from the reading that is given by the European Court to a very similar phrase in the Brussels Convention. My lord, my lady, going back to section 12, the section 12.1, the respondent's construction seeks to break down section 12.1 to establish two separate requirements. First, that the writ or other document is required to be served, and second, that the writ or other document thus required to be served institutes proceedings against a state. Now, even if this is an available construction on the syntax of the sentence, one has to make a choice as to whether that best reflects the context in which the provision appears in the statute. And we submit that it does not, because on general dynamics construction, section 12.1, which is a mandatory requirement, could very easily be bypassed by a judge simply dispensing with the need for service. And so by that simple expedient, the professed requirement of service is done away with. And no one could appeal that. We submit that the context of section 12.1 within the statute is inimical to that construction. First of all, if one looks at the rest of section 12, one sees section 12.2, which provides that the time for entering an appearance by the state shall begin to run 2 months after the date on which the writ or document is received, as aforesaid. As aforesaid. And we submit that that clearly envisages service in accordance with section 12.1 as a prerequisite for the state entering an appearance. Yet on the respondent's construction, in a claim to enforce an arbitration award against a state, the major or a major class of claims against states, there would be no reason to serve as aforesaid. And so time under section 12.2 would never begin to run against a state. And the paradox of that is that in their pro-arbitration zeal to allow speedy enforcement of awards by dispensing with service, if time never begins to run against a state, the state will never have to enter an appearance. But that could work against a state, because if the law is as the Court of Appeal has said it is, the state may never come to have knowledge of the proceedings, and yet once an enforcement order is made, its assets are in jeopardy. That cannot be right. Another contextual consideration within the statute is section 12.4, which says that no judgment in default shall be given against a state on proof except on proof that subsection 1 above has been complied with and that the time for entering an appearance as extended by subsection 2 above has expired. It's the same point. If a claimant eager to enforce an arbitration award doesn't have to comply with the requirements of section 12.1, it will never get a judgment in default, because time for entering an appearance in accordance with subsection 2 will never have expired.
But are we concerned at all with entering an appearance or now an acknowledgement of service?
My lord, we would be, because in enforcement proceedings, yes.
In enforcement of an arbitration award?
Yes. There would have to be an acceptance by the state. The state has to be impleaded and come before the court. My lord, Lord Briggs has a question.
As I read section 12.2, it isn't prescribing that in every claim against a state there must be a process for the state to enter an appearance, or I think we would now say acknowledge service. It's saying, isn't it, where the rules of court, or I suppose a statute, in our jurisdiction for which this act was passed requires the entry of an appearance, then there's a 2-month add-on before time under that rule begins to run. And it contemplates, therefore, that there may be proceedings against a state where there isn't any provision for the entry of an appearance. And I think the point of Lord Jones's question is, well, arbitration is one of those, unless you can point to some rule that requires in the arbitration enforcement process some requirement for acknowledgement of service.
Yes. Well, my lord, I'm grateful for that explanation. We'll perhaps come back to that, if I may. But even allowing for the fact that section 12.2 is not mandatory in the sense that every claim requires the entry of an appearance, it is an important contextual point in respect of such claims as do require an entry of appearance. Because, of course, this construction has to work not just for claims to enforce arbitration awards, but all manner of other claims, including claims where there is a requirement for entry of an appearance. And so we do still rely on section 12.2 as an important contextual point. And then, my lord, my lady, section 12.6 is an important contextual point, albeit a different one. And that requires, that states that subsection 1 doesn't prevent the service of a writ or other document in any manner to which the state has agreed. And subsections 2 and 4 above do not apply where service is effected in any other manner, in any such manner. And that makes the point that a foreign state can agree to a different mode of service of process on it. That is its prerogative. And that's important because if a claimant wishes to avoid delay or inconvenience of service through diplomatic channels, in any contract with the state containing a dispute resolution clause, it can negotiate for different arrangements. So there's no unfairness at all in requiring service on a state in accordance with section 12.1 as we construe it in relation to an arbitration or an arbitration award, given that a claimant could have freely negotiated a bespoke or different service of suit provision.
I'm sorry, Mr. Matthew, I'm going to have to ask you to repeat that because we lost the connection for a minute.
Indeed.
And I'm also told that we're having difficulty connecting to the network.
My lord, I'll repeat.
If you repeat your last sentence, that would be good.
There's no unfairness at all in requiring service on a state in accordance with section 12.1 as we interpret it in relation to an arbitration or an application to enforce an arbitration award, given that a claimant could have freely negotiated a bespoke or different service of suit provision in its contract with that state. And if the state refused to agree a different service of suit provision, well then a claimant would simply have to consider whether or not that was a deal breaker. That's capitalism. And now I invite the court to consider a provision which the authorities have always overlooked, and that's section 21 on page 19, or perhaps it's 20 of the bundle. And that's the provision request. We've lost Lord Lloyd Jones. My lord, I was taking the court to section 21 of the State Immunity Act. It's a point I have made already, so I don't need to repeat it. It concerns the conclusive nature of the certificate which the Foreign Office is to produce following its transmission and any receipt of the process papers by the foreign state. And that demonstrates in our submission the significance of the special process under section 12 and the importance also of leaving these matters of service to the Foreign Office to determine when and how service is to be, and in due course has been effected. My lords, my lady, I then invite the court to look also at section 15, going back a little as part of the contextual consideration, which is on page 16, or is it 17 of the electronic bundle. Section 15, restriction and extension of immunities and privileges, which makes the point that the executive, Her Majesty in Council, has the right to restrict or extend the immunities or privileges afforded by the State Immunity Act of foreign states, including the procedural privilege of service, in respect of service, if Her Majesty's government concludes that it is not being treated in the same way by the foreign state. And that shows that these are matters for the executive to determine, having regard to relations with foreign states. It is not for judges to interfere with, in any given case, in the exercise of judicial discretion from the Strand. So if a state decides to give judicial discretion to its courts in respect of service of process on the United Kingdom, it would be for the executive of the United Kingdom to determine whether or not section 12(1) should be amended to bring equivalence, not for judges exercising discretion. And finally, section 19(1)B on page 18, or is it 19 of the electronic bundle, which states that a court need not give effect to section 18, which concerns recognition of judgments against the United Kingdom, in the case of a judgment B, if the judgment was given without provisions corresponding to those of section 12 above having been complied with, and the United Kingdom hasn't entered an appearance or applied to have the judgment set aside. And so that provision shows that the United Kingdom expects to be served via diplomatic channels itself, a contextual pointer, in a case where it is a defendant. And the respondent's case simply doesn't address all these contextual pointers within the statute. Now, my lord, my ladies, I cannot go through, unfortunately, the authorities that I would have wished to take the court to. I can only, in the time available, mention the case of Van Gil and Lesotho, a decision of the High Court of Singapore, which interpreted sections 14 of the State Immunity Act of Singapore. The State Immunity Act, in particular section 14 of that Act of Singapore, is a copycat piece of legislation copying Section 12 of the UK Act. That is perhaps a unnecessarily disparaging description of Section 14 of the Singapore Act, but I hope the court gets my point. It is in pari materia with Section 12 of the State Immunity Act of the UK. And Van Gil and Lesotho is in the primary authorities bundle at page 976. And we haven't got time, or I haven't got time to take the court to it orally, but I do urge the court with respect to read the judgment of Mr. Justice Ramesh in that case with great care, because the learned justice went very carefully and thoroughly through the text of Section 14 of the State Immunity Act of Singapore and the policy reasons underlying that provision. And we adopt his reasoning as part of our case. Now, the Court of Appeal below dismissed Mr. Justice Ramesh's judgment in Van Gil on the grounds that they did not consider that it was on all fours with the case before it. It was suggested that the rules of court in Singapore, which the learned justice was considering, were different from the CPR which the Court of Appeal was considering, even if the statutory provisions were in pari materia. When your lordships and your ladyship come to look at the Van Gil judgment, in that respect, we would invite the court to look at paragraphs 27 to 32 of the judgment, where Justice Ramesh put side by side the provisions of the CPR and the relevant provisions of the Singapore Rules of Court. And he concluded that there was no material distinction between the two. In our respectful submission, Van Gil is very much a case which we urge upon this court, and which the Court of Appeal did not address at all in substance in its judgment. My lord, my lady, I then turn to the question of policy considerations, having looked at the contextual issues that arise. The policy considerations we address in our written case in relation to the policy as to the need for service through diplomatic channels, paragraph 3.5 to 3.10 of our case. In particular, we refer the court to paragraph 3.8, quoting the report of the Australian Law Reform Commission, which preceded the enactment of the Australian Foreign State Immunities Act. And that was a report which appears in our bundles, a report written by Professor Crawford, who will be well known to the court. And we certainly urge upon the court, in particular, the passages from that report which we have quoted in our case. We also refer to paragraph 3.9 to 3.10 of our case, including the passage quoted there, which is important on the issue of the policy considerations. I'm just reminding myself, if not the court at this stage, of what is said there. Yes, this is the quotation from the report. It's page 68 of the core bundle, which makes the point about service through diplomatic channels, paragraph 3.8, being guaranteed to bring the suit to the attention of senior officials of the foreign state. fulfilling the criterion that service must give the state adequate notice, and that the diplomatic channel is least likely to cause offence to recipients. But it's the point of a guarantee, which works for the benefit of a claimant as well as of the defendant foreign state, a guarantee that the foreign state, or the best guarantee there is, that the foreign state will actually get notice of the claim. And the risk of offence in foreign relations is not an imaginary risk. It is well borne out in the cases which have come before the courts. For example, when the court reviews the Heiser case, which is in our primary authorities bundle, tab 13, page 414, it will see that that was a case against Iran for damages for allegedly state-sponsored terrorism emanating from judgments of the US courts. And the Iranian authorities took the view that those were political judgments which they were to would have no truck with. And on paragraph 37 of the judgment, one will see the witness statement of the deputy head of mission at the British Embassy in Iran, speaking of attempts to serve process on the Iranian Ministry of Foreign Affairs and being met with threats that service will cause a rupture in relations between the countries if conducted by what the Iranian authorities termed as subterfuge. Now, that may have merely been a threat, but it was something which the British head of mission, deputy head of mission, had to take and did take seriously. These are preeminently matters on which the Foreign Office is best placed to judge how best to effect service, even if that may not happen as quickly as a lay claimant may wish. And that then brings us to the present case, and to the particular order that was made by Mr. Justice Tier, which the Court of Appeal has restored. And may I ask the court to look again at the order that Mr. Justice Tier made. That's in the core bundle, I believe at page 163. It may be 164. Well, it starts at 163 or 162, and I was going to take the court to paragraph 5. And this is the order, paragraph 5, for alternative service. No, it's for notice. It's not for service. It's for notice. And what Mr. Justice Tier ordered was that the claimant could courier the arbitration claim form and this order and associated documents to 3 addresses. First, the Interim General Committee for Defence in Tripoli. Second, the Ministry of Foreign Affairs in Tripoli. And third, a law firm in Paris, being the law firm which had had conduct of the arbitration on behalf of Libya. Standing back, what was envisaged here? What was envisaged was that in the exceptional circumstances described by Lord Justice Males, which the Court of Appeal said that it had no reason to depart from, the exceptional circumstances of danger in service in Tripoli, a courier could deliver the documents to the Interim General Committee in Tripoli and the Ministry of Foreign Affairs in Tripoli. One can imagine it. Someone on a bike turning up at these buildings, asking whoever he or she met to sign here, please. Is that really adequate notice, let alone service, on a state? And your ladyship and your lordships are no doubt as alive as my client is to the irony of the Court of Appeal restoring an order permitting service by courier, notwithstanding the description by Lord Justice Males of conditions in Tripoli as being exceptionally dangerous. Give it to the man in Lycra, it's too dangerous to be left to the Foreign Office. In any event, even if Lord Justice Males' concerns about the situation in Tripoli were a real problem, service might have been affected at any time by the Foreign Office. And as for service on the law firm in Paris, which acted in the arbitration, what if that law firm were not instructed to accept service? A point made by Mr. Justice Ramesh in the Van Gil case when the court comes to read it. We say that cannot be an adequate substitute for proper service. And when one thinks about it, the order in relation to notification to a foreign sovereign state of enforcement proceedings in this case, which the Court of Appeal restored and which General Dynamics wants this court to uphold, and to allow other judges to have the ability to emulate in the future, is wholly inappropriate. As it was, in this case, the state of Libya came to know about the proceedings not by those methods set out in paragraph 5 of the order, but by the pure happenstance of a young lawyer in my instructing solicitor's office reading about it in an arbitration magazine. The things one has to do to get a job in a top law firm these days. And as to the importance of service as opposed to mere notification, for the court's note, we invite the court to look at Van Gil at paragraphs 36 and 42 to 44. We also invite the court to look at the case of Barton against Wright Hassel, which is cited at paragraph 5.15.4 of our written case, the judgment of Lord Sumption in that case. Similarly, we refer to the introduction by Lord Wolfe to his Access to Justice report, which is one of the authorities more recently added to the bundle, paragraph 6 of chapter 9, talking about the importance of service. And we say, given the importance of service as opposed to notice, it's wrong in principle that service should be dispensed with, particularly where there's no good reason for doing so. And that leads me to the case, very briefly, of Union, Fenosa, and Egypt, which is at page 2118. We glanced at it earlier. That was a case concerning the enforcement of an ICSID arbitration award, where Mr. Justice Jacobs found that the order of Mr. Justice Males, as he then was, granting permission to enforce, had in fact been transmitted by the Foreign Office to the Egyptian Ministry of Foreign Affairs in accordance with Section 12. So Section 12 had been complied with. However, it had been returned by the Egyptian Ministry of Finance on the basis that the Egyptian Ministry of Justice was the appropriate department of the Egyptian government to deal with the matter. Mr. Justice Jacobs held that for the purpose of Section 12, the fact that the Egyptian government said that it should be the Ministry of Justice, not the Ministry of Foreign Affairs, that should deal with these matters is irrelevant. And we say, so far, respectively, so good. But he then granted an application to dispense with service of the order in that case, notwithstanding that service in accordance with Section 12 had been complied with as he found. He granted an application to dispense with service in order to regularize the position, as he said, so that there could be no doubt. Now, we submit that that was wrong in principle, and that the court could and should simply have made a declaration if it thought necessary that the requirements of Section 12 had been complied with. If your lordships and your ladyship are with me on Section 12, we invite you to disapprove that decision in Union Fenosa. That then brings me as fast as I can to the alternative case of my learned friends on the interpretation of section 12, where they set out that case paragraphs 18 to 20 of their written case, page 93, or is it 94 of the core bundle, where they submit that the order of the Court of Appeal should be upheld on an alternative basis, that the statutory requirement that a document is one which is required to be served ought to be and can only properly be determined by reference to the totality of the relevant procedural rules, including any judicial power to require or dispense with service. Now, reliance on the discretionary powers of the court is fundamental to General Dynamics' primary as well as alternative case on this appeal. And this alternative case in our submission gives the game away. CPR Part 6.1 shows that this argument is in any event misconceived, because CPR 6.1 makes it clear that the Part 6 rules about service apply, and I quote, except where another part, any other enactment, or a practice direction makes different provision. So Part 6 cannot be used to override or to read down a statutory provision like Section 12(1) of the State Immunity Act. But even if the proposition for which my learned friends contend in paragraph 18 were correct, the consequence would be extraordinary, because the CPR would thereby give the court discretionary power to dispense with service of any claim form in exceptional circumstances. That's what CPR 6.16 says, or any document at all. That's what CPR 6.28 says. And if that were not enough, there would also be a discretion looking at the totality of the procedural rules in this case. There would also be a discretion under CPR 3.1M, M for mother, which sets out the court's general case management powers in addition to powers given by any other rule, M granting and expressing the power, quote, to take any other step or make any other order for the purpose of managing the case and furthering the overriding objective. So by taking into account the totality of the court's discretionary powers to dispense with service or to move a case along, it can be seen that the statutory privilege granted to foreign states would be completely destroyed. They would be no different from any other litigant, and that, in our submission, is plainly not the legislative intent behind Section 12. My Lord, that leaves me the remodeled ECHR point, Section 3 point, and I wonder if, given the interruptions we've had, I could be allowed 2 minutes to make
Yes, of
some
course.
submissions.
I'm sorry about the interruptions. I was going to allow you a
Sure,
few
my lord.
minutes.
I'm
And
grateful.
if you need to, I can allow you until, well, a couple of minutes. But if you need to go
Yes.
beyond that, you can eat into the time allowed for your reply.
Well, that may be something, because I wouldn't want to eat into the time allowed for my lunch. So, my lord, the remodeled point, 3 points I can deal with. First of all, if a proper interpretation of Section 12(1) otherwise leads to the conclusion for which we contend, namely that it is a mandatory rule of service, a rule for service of states through diplomatic channels, it's difficult to see how any Article 6 point is engaged, because the respondent makes it clear in its written case that it's not seeking a declaration of incompatibility. That's paragraph 21 of my learned friend's written case. Now, that being so, in our submission, there's no reason at all or need to read Section 12 any differently by virtue of Article 6 of the Human Rights Convention, and Section 3 of the Human Rights Act. What the respondent is doing by raising this point is simply asking for a more favourable interpretation of Section 12(1) of the State Immunity Act, whilst accepting that no declaration of incompatibility is warranted if Libya's interpretation is adopted. Second point. The respondent's argument is, in any event, premised on a set of assumptions which is misconceived. May I take the court to page 99 of the core bundle? I'm sorry, to paragraph 99 of its case, of the written case of the respondent, which is at page 123 or perhaps 124 of the core bundle. If the construction advanced by Libya is accepted, the effect will be A, notwithstanding that the defendant state has no state immunity, and B, notwithstanding the existence of exceptional circumstances. Nevertheless, C, proceedings against that state cannot progress because Section 12(1) requires such service to occur. Now, we don't accept the proposition that Libya has no state immunity. That position is reserved, and it will be for another day. And in relation to the question of whether or not Libya has state immunity, may I invite your lordship and your ladyship to take a note of the jurisdictional immunities case in the ICJ at paragraph 113, where the International Court of Justice discusses the point about immunity from enforcement. That's in the primary authorities bundle at 1065, I believe. Paragraph 113. There certainly is every prospect of immunity from enforcement. But at the very least, we say, Libya can invoke state immunity in respect of any assets against which enforcement is attempted. And the burden will be on the claimant to establish that there is no immunity. As for the second premise, exceptional circumstances, even if we are not challenging on this appeal whether or not the circumstances were exceptional, a concern about the specific facts of a given case is not a reason to read in words which change the meaning of the enacted legislation for all time and for all circumstances. Third, there is and would be no breach of Article 6. If the statutory requirements reflect generally accepted principles of international law, and we submit even international practice of between states, that does not impose a disproportionate restriction on the right of access to the courts so as to require Section 12(1) to be read down. And for the court's note, we refer to the case in the European Court of Human Rights of Wallehauser and Austria, which is in the primary authorities bundle at page 7, particularly at page 771 and following. We refer to the following paragraphs 57, 64, and 68 to 69, where the European Court of Human Rights made it clear that the service through diplomatic channels on a state was a principle of customary international law. We also refer to Article 22 of the UN Convention on State Immunity, which has been described in Belhaj and in Jones and Saudi Arabia as an authoritative statement of customary international law.
Do you say,
Yes.
Mr. Matavu, that there is a rule of international law, customary international law, which requires service on a state to be effected through diplomatic channels?
My lord, our submission is yes, that there is a rule of customary international law which does require that, which is reflected in Article 22 of the UN Convention.
Thank you.
But that if your lordship and your ladyship are against me on that, there is certainly a wide practice across many states which is relevant to take into consideration when considering proportionality for Article 6 grounds in any event. I don't have to put it as high as a rule of customary international law. It is certainly a widely accepted rule of practice. And we have identified jurisdictions where that practice has been adopted in legislation. We do that in our written case. We refer to Canada and Singapore and Australia. And if and insofar as there are other jurisdictions which do not have that in their legislation, nevertheless, the practice is relevant on the question of proportionality.
Right. Now, Mr. Matavu, you're 5 minutes into your reply time.
I've done, my lord, unless your lordships and your ladyship have any questions. Thank you.
Thank you, Mr. Matavu. I don't think there are any questions. Mr. Toledano.
My lord, as the court knows, we advance 3 reasons why we say that section 12(1) does not apply, and they are set out in paragraph 46 of our written case, which is at page 57 of the key documents bundle. If the court agrees with any one or more of them, then the appeal should be dismissed. And as the court knows, the Court of Appeal agreed with the first, but summarily rejected the second, and we didn't run the third, which was the Human Rights Act point in the Court of Appeal, but we do so now, as you know, in response to this appeal. Now, I'm going to, with your permission, deal with each of these 3 reasons in turn, before finally dealing with Libya's new argument based on customary international law. But before I turn to those 3 reasons, there are a few overarching points that I'd like to make by way of introduction, if I may. The overarching points we make begin with the proper approach to the issues raised by this appeal. The correct starting point is, of course, to give section 12(1) its ordinary and natural meaning, having regard to its context, and that is what Lord Clark said as regards the 1978 Act in the Servas against Raffidain Bank case, which we've set out in our written case, and Lord Bingham in Jones against Saudi Arabia likewise said that the duty of the English court is to apply the plain terms of this domestic statute. Now, in addition, of course, it's necessary to read and give effect to section 12(1) in a way which is compatible with the claimant's right of access to the court under Article 6 of the Human Rights Convention, so far as is possible. And in our submission, the court will only have recourse to customary international law if there is ambiguity or doubt about the meaning of the statute, and that would be on the basis that Parliament can be expected to have wished to legislate consistently with it. And that, in our submission, could only extend to customary international law as it stood in 1978. The only other role that customary international law could play is as an answer to our argument based on Article 6.
Well, pausing there for a moment, Mr. Toledano, does that mean the interpretation of the State Immunity Act is frozen as reflecting customary international law at 1978?
Well, it may not necessarily have to produce that result. It's just that when you look at the way Libya has put its case on customary international law, front and center of its case is a convention, the UN Convention, that was adopted in 2004. And Libya has done nothing to suggest in its case, or to put forward any materials to suggest in its case, that the rule enshrined or adopted in Article 22 was a rule of customary international law that had been in existence for a long period of time and was already in existence in 1978. So we say the way that Libya's put its case, based on the UN Convention, which was in 2004, many, many years after the Act, and without in any way going into material suggestive of a rule of customary international law of application at an earlier stage, we say that can't possibly work as an argument. And Libya hasn't done anything to try to explain how it relies on the UN Convention in the context of a 1978 Act.
Thank you.
The other role...
Sorry, Mr. Tiller. I understand that you submit that the Act is ambulatory in relation to procedure. And I can't understand why it shouldn't also be ambulatory in relation to customary international law. Well,
so my answer to that, I'll give two answers to that. First of all, let me make it clear that even if we are wrong and that the court can have regard to customary international law in an ambulatory way as well, then we make the same point, which is that there is no rule of customary international law, whether as at 1978 or as at today's date. And I'll come on to that, but there is no rule of customary international law, and we have developed that point in some detail in our written case. So I make that clear to begin with. The second point I would make to my Lord Stevens' question is that there is, we submit a difference between the two, and that's because Section 12.1 does require the court to have regard to the rules of court, because it says required to be served for instituting proceedings, and the question of what is required to be served for instituting proceedings can only be answered by reference to the rules of court. And as I'll come on to in due course, the rules of court are actually expressly referred to in Section 12 in several of the subsections. By legislating referentially in that way, and we've relied on a principle from Bennion for this point, the statute must have intended to refer to the rules as they changed over time, and that's otherwise it wouldn't have referred referentially to the rules of court in that way. Now, by contrast, customary international law is obviously a different thing entirely. It's not referenced in that way in the statute. Therefore, most obviously, it comes into play as a matter of context for the 1978 Act, hence why we say, most obviously, that would be the position as customary international law stood then. But I make it clear that this is not an important point. The timing point on that point, customary international law, is not important for our case, for the simple reason that we say on the materials it's abundantly clear that there was no rule then and there's no rule now in relation to mandatory diplomatic service.
Thank you.
Now, the only other role that customary international law could play, we submit, is as an answer to our argument based on Article 6, and that would only work if there now exists a rule of customary international law that removes the court's adjudicative jurisdiction, and I'll come back to that. Now, our case in a nutshell, as you know, is that the wording of Section 12.1 is clear. It only covers documents which are required to be served and which are for instituting proceedings. It does not apply to ex parte proceedings, and it does not apply if the court has dispensed with service. And at no stage has Libya advanced a proper argument based on the language of the statute. It simply asserts that regardless of the language used, there must always be a document falling within the statute. And we say that assertion is inconsistent with the way the subsection is drafted.
Am I right in understanding that before the machinery for enforcement can actually be employed, it is necessary to serve either the application or the order made on the application?
Absolutely, my lord, yes. Under 62.18, and I'll come to show you this in due course, if the matter proceeds ex parte, which is how it normally does proceed,
yes,
then there's no obligation to serve, obviously, the claim form, the arbitration claim form, because it's ex parte. But when an order is made by the court, under 62.18, there is an obligation to serve the order. But our argument is that order is not a document within section 12.1 because it's not required to be served for instituting proceedings. On the contrary, the proceedings have already been instituted at that point. They've been on foot for several weeks and so on.
I understand that. I understand that, but I just wanted to be sure that I've correctly understood that the machinery can't work unless at some point the state is served with notice of the proceedings.
Yes, we would accept it. We would have to be given notice of the proceedings. That was achieved in the present case by an order dispensing with service, but with a requirement that the state that steps be taken in all the ways that your lordship has already seen in the ex parte order of Mr. Justice Tier to bring the proceedings to the attention of the state. And my learned friend says, well, actually, they found out about it by reviewing some arbitration journal. They also did receive it in the other ways. One of the ways, in fact, became impossible because it was too dangerous to courier. But the other two ways, service on the law firm in Paris and service on one of the ministries, were possible eventually after military personnel were brought in to effect the couriering.
Yes, thank you very much.
I should say ex-military personnel.
Right, and my lady, Lady Arden has a question.
Could we know precisely what you said to the Foreign Office and what their response was? You may want to do this after the short adjournment.
My lady, you've seen the paragraph 84 of Lord Justice Miles's judgment, where he says something about that. What you weren't taken to was paragraph 87 of his judgment, which in the key documents bundle is at page 140, where he says that the evidence suggests that the stated view of the Foreign and Commonwealth Office is that, quote, service of documents on the ministry in Libya is not at all straightforward, too dangerous, and assuming it to be possible at all, likely to take over a year. That's at the end of 87. In the Court of Appeal's judgment, they also refer to that bit of the evidence in paragraph 3 of their judgment, which is at page 96 of the same bundle.
Sorry, which paragraph? Sorry, which paragraph?
Paragraph 3 at page, in my bundle of the key documents, it's at page 96. It may be +1, 97.
Yes, thank you.
And then if you also look in the Court of Appeal at paragraph, I think it's 64, 65, which is probably at page 115, you can see they set out there again the reference to the FCO material, and they concluded, having looked at all that material, because it was in evidence in the Court of Appeal, they said the FCO's own lack of enthusiasm for the process is palpable. Now, in answer to my lady's question, I don't think the underlying witness statements and exhibited emails to and from the FCO are in the bundles before this court. So what this court has in the bundles at the moment is the material that I've shown you in the judgments. The reason for that is simply that there is no permission was sought and there is no appeal from Libya on the question of exceptional circumstances.
What was asked?
I'm sorry, I didn't hear the full question.
Very well, my apologies. It is said that the Foreign Office were not squarely asked to effect service. They were simply discussions. And are you saying they were squarely asked? And if so, could we have the reply?
Well, my lady, I'll have to check precisely what words were used, but essentially what I've shown you in the judgments was the reply. In other words, if it was possible at all, it would take a very long time, that it was too dangerous, and they were really saying that there was a question mark over whether it could happen at all. So I don't think it's fair to characterize it as us not asking. We did ask, we did get in touch, and that was the response that we got. And your ladyship will, of course, bear in mind that the embassy, the British embassy in Tripoli, closed in 2014, so it's been closed or suspended for more than 6 years now, and this was the answer that we got from the FCO.
Yes, but that happened in Iran too. Just my question: were they squarely asked to effect service, and what was the response?
So in terms of the response, you've seen the material on the response. In terms of the question, I think I'll come back to your lady's question, if I may, because I want to check the, if I can, over the short adjournment, the precisely what was in evidence about what we asked.
And this presumably was in evidence before Mr. Justice Tier.
Yes, it was, my lord, and in front of Lord Justice Mayles when the matter came back into parties, and indeed in front of the Court of Appeal, because Libya did appeal on exceptional circumstances, and the appeal was rejected by the Court of Appeal.
Yes. Well, I think we should see that material.
My lord, yes, of course.
My lord, Lord Burrows has a question.
Yes, just before we leave the point, you said that your opponent had said nothing about the interpretation of the word instituting proceedings that would be contrary to the approach that you're putting forward. But I think it was said against you that what it means, or can be taken to mean, is it's the means of first getting a party, here the state, before the court for the purpose of enforcement proceedings. And that is a valid interpretation of instituting proceedings in the context at which we're dealing. Now, what's wrong with that?
Well, that was said this morning. Your lordship is quite right about that, of course. What we say about that is that's simply not what the statute says. It says for instituting proceedings, and it's been well known always that proceedings are instituted by the issue of a claim form. And my learned friend doesn't like that because he wants to have some wider meaning, established proceedings, I think he said this morning. But that is not the way in which the Section 12 is drafted. Section 12, as we'll come to, is absolutely replete with references to the rules of court. It mentions writ, it mentions entry of appearance, it mentions judgments in default, it refers to the rules of court 3 times. And so the whole context of Section 12 is the rules of court, and we know that under the rules of court, a set of proceedings is instituted when the claim form is issued, and that's obviously important for limitation purposes, for lots of other purposes as well. And to say, well, it could be interpreted to mean something broader, in other words, when you put a document to the state for the purpose of bringing them to the court and so on, we say that's simply not what the statute has in mind. And I would add one point as well that's specific to the ex parte process, which is, I think at one point my learned friend said, well, you at the point that you get the order, it's then in the ex parte context that you are commanded to appear before the English court. Well, that's obviously not right, because that's not how the order works. The order, unlike, for example, a writ, the order giving permission to enforce an arbitral award doesn't command the state to do anything. The state is given an opportunity to apply to set aside the order if it wishes to do so, and is given a period of time in which to do that, and so on. But it isn't commanded to appear before the court in the way that it would be if there had been a writ or an originating summons or something of that kind. And that's why we say, one of the reasons why we say, and there's many, but that's one of the reasons we say that the ex parte process is something different in kind.
But it is a precondition. It is a precondition to enforcement, Mr. Toledanis, so that if it's not served, as I think you accept, if it's not served, then there's no way in which the enforcement procedure can follow.
Well,
so it is an essential way of bringing the foreign state within the jurisdiction of the court.
Well, what it is, my lord, is you get the order, and then under the rules of court, the order has to be served, and we accept that. But once you're in that territory, there's no reason why the state should be treated differently to any other litigant. In other words, you are able to deploy, the court is able to deploy the rules relating to dispensing with service. And so at that point, the court is able to say, well, the circumstances are exceptional. We will ensure the state is notified in some other way, but we're not going to allow these proceedings to be frustrated simply because it's impossible to serve through the one method identified in Section 12.1. So
That depends on whether Section 12 imposes an overriding requirement.
It does, my lord, and absolutely. And I'm coming back to how we interpret the statute. We say it doesn't, and we say it doesn't generally, but it certainly doesn't in the case of ex parte processes.
Thank you. Now, my Lord Stevens has a question.
For interrupting, and it's very close to 1 o'clock. Over lunchtime, could you provide the answer to the question as to whether an appearance is necessary in arbitration proceedings, and that refers to the actual rule. But the question I wanted to ask was, does this lack of notification to the state extend to Mariva injunctions, Anton pillar orders, prohibitory ex parte injunctions to prohibit the state from doing certain things commercially, for instance, in the territory? Does it extend to all those ex parte applications?
Well, the answer to that is I'd have to sort of check over the lunch adjournment, the specific ones you've mentioned, but most likely some of those would be caught by Section 12 because there would be a document that was required to be served for instituting proceedings. So even if you begin a process, for example, for a freezing order, and you begin it ex parte, you are usually, perhaps always, ordered to serve the originating document after you've got the ex parte order, and you have to serve the claim form. So the rules don't provide that you don't serve the claim form. You do serve the claim form even if you've obtained the order ex parte. The difference with enforcement of arbitral awards, and this has been a difference all the way along with those processes, is that you are not required, explicitly under the rules, you are not required to serve the claim form. It says you do not have to serve the claim form unless the court directs that you should serve the claim form, in which case it doesn't proceed ex parte at all. So there's a very specific procedure, which is all part and parcel, we say, of an important policy consideration for the enforcement of arbitral awards, which I should add, and this is very important, and I'll come back to this, is not just a policy, if you like, in general. It's a specific policy that underpins Section 9 of the State Immunity Act. And I'll come back to that. But we say that policy about enforcement of arbitral awards is something rooted in this Act itself.
Mr. Toledano, in relation to my Lord Stevens' question, it may assist if I draw attention at this point, you can think about it over the adjournment, to Section 13, subsection 2A, which says that subject to subsections 3 and 4, relief shall not be given against the state by way of an injunction. And,
yes,
and there are then specific exceptions in subsection 3, with the written consent of the state, and 4, without prejudice to process in respect of property in use or intended for use for commercial purposes.
So it may be that some in the list would not be possible against the state anyway for that reason.
Yeah.
My lord,
yes. That's the point. You might like to think about that over the
years. Yes, I will, my lord. There
we are. Well, it's just gone 1 o'clock. I think that's a convenient point. We'll resume at 2. Thank you very much.
Thank you.